the framers were concerned about government overreach in a lot of different areas. The provisions of our Constitution are protecting individual liberty from government overreach. This is why we have provisions about limited government. And there are many provisions in the Constitution that are limiting government action when it comes to the deprivation of liberty, because the framers understood how important liberty is to our society. And so there's the Fourth Amendment, there's the Fifth Amendment, there's the Sixth Amendment, there's the Eighth Amendment. These provisions are crucial, and it is zealous defense counsel that ensures that the government is protecting these rights, that ensures that these rights are protected and that people are getting due process in the criminal justice system.
And joining us now, Michelle Batcher Goodwin, Chancellor's Professor at the University of California, Irvine Law School, and host of the podcast On the Issues with Michelle Goodwin. Also with us, Rakeem Brooks, President of the Alliance for Justice and a public interest appellate lawyer. Professor Goodwin, let me begin with you. And the reason we showed that particular piece of her testimony is this is one of those rare moments where we have a Supreme Court nominee who has actually represented criminal defendants in courtrooms in trials.
That's right. And let's be clear, this is critically important. The first 10 amendments of the U.S. Constitution, known as the Bill of Rights, protects individuals from the tyranny of the state. As she enumerated, many of those amendments directly speak to protecting people who have been accused of crimes by the government and protecting their interest. It's something that previously was a revered aspect of our Constitution, and we appreciated the public servants who dedicated themselves to serving on behalf of people who are indigent criminal defendants, such as then public federal defenders or just public defenders, those who represent people at the state level. So this is a noble calling that she has taken up in the past. And unfortunately, what we've seen is a kind of level of scorched earth politicking today with regard to what otherwise has been perceived and understood as a very noble calling. And in fact, the importance of zealous advocacy, which is not just something that lawyers can put up or put down, but is actually required by a code of ethics that lawyers must adhere to. She doesn't get to choose.
Rakeem Brooks, what did you take away from the hearing in terms of important points made by the nominee?
Ultimately, what we witnessed was her sheer brilliance. I just smiled watching the clip at the very beginning. We all know how extraordinary she is from day one, but today that was on display for multiple hours under really grueling conditions. And I think the point that she made most clearly was that she really is a judge's judge. She looks at the facts, she looks at the law, and she applies it equally, regardless of the parties before her. She's not favoring the wealthy and the powerful. She's not favoring any party. What she does as a judge is looks at the facts, looks at the law, and applies it. And so many times Republicans tried to corner her and say, are you a originalist or a textualist, as a way of trying to almost say that those were the neutral principles by which our legal system should be governed. And the truth is those principles are not are at all neutral. They tilt in a particular direction. And she avoided that because she's a judge's judge. She looks at the facts, looks at the law, and applies it.
Professor Goodwin, I think in especially the most recent confirmation hearings, the last few decades, we've been seeing some very carefully constructed resumes, nominees from Democratic presidents and Republican presidents. And you can see caution in those resumes, including if I'm going to work as a trial lawyer in a criminal case, it better be prosecutor, because they'll be okay with that. That's in right. Senate confirmation hearings. There's just a whole set of career choices you can see people making. And here we see a nominee who made the risky choice of saying, no, I will stand up as a federal public defender for whoever is assigned to me. She didn't even get to choose who she would be representing. What message does that send to young lawyers, people in law school now, who are thinking about just how do they want to shape their resumes so that they might someday be able to get through one of these hearings?
Lawrence, I'm glad that you asked that. There are two things that come through and more. One is her integrity, because you're absolutely right. There are law students who become nervous about even the potential of becoming a law clerk based on what they may write. And what we saw today was pure courage and integrity that has spanned a career. But there's something else that we've seen, given some of the vitriol and some of the unfair innuendo and inflammatory attacks. We see the strength that Black mothers pass on to their daughters, their granddaughters, and their nieces, and that is to walk through fire. And what we've seen is her ability to do that with poise, grace, and dignity under questioning that, as you mentioned, would have been off the table at another time.
Rakeem Brooks, what about that point that law students, young lawyers, are very carefully shaping their resumes for these kinds of moments? And Judge, this nominee is showing you that you might be able to do some things that you didn't think you could do.
I think it's incredibly important, and Professor Goodwin is exactly right. She's teaching law students all the time who are making calculations about what their careers will look like. And for the first time, they're going to look up at the Supreme Court in just a few months and see someone who honors one of our most cherished rights, right? When we think about Miranda, right before they tell you that, before they put you in cuffs, they tell you have an entitlement to a lawyer. And if you cannot afford one, one will be provided to you. It is as bedrock a principle in American law as anything. It's what makes us free. And for a long time, people avoided that to some extent because they were afraid that at confirmation hearings, just as we saw today with Senators Cruz and Senators Hawley, that they would be attacked for representing clients and defending that constitutional right. No more. Now law students will look ahead and say, she stood there with courage. She defended the Constitution as she has her entire career. And now she moved on to the Supreme Court, where she will continue to defend the Constitution of the United States. It's a glorious moment for us all.